To everybody. The advisory group of experts is conducting interviews today with candidates for the position of a judge of the Constitutional Court of Ukraine. And our next candidate is Mr. Tkachenko Oleksandr Vasilyevich, who was admitted to competitive selection by the decision of the Council of Judges of Ukraine. Mr. Tkachenko is a retired judge of the Commercial Court of Mykolaiv region. We are ready to start with the interview. That's why I'm giving the floor to the secretary of the advisory group of experts, Mr. Yaroslav Romaniuk, to explain the algorithm of our work today and to moderate the interview. Please, Mr. Secretary.
Thank you, Mr. Chairman. Good afternoon, Mr. Alexander. Good afternoon, everyone who is watching our live broadcast now. At today's meeting of the AGE, all 6 members of the AGE are present. Some of them are present here in person, and some of them are present by means of video conference mode. In particular, we have the following members present: Chairman of the AGE, Mr. Alex Zalar, members of the AGE, Ms. Hanna Sukhotska, Ms. Maureen O'Connor, Ms. Oksana Vasilchenko, member of the AGE, Mr. Vasil Shakun, and I, Secretary of the AGE, Yaroslav Romaniuk. Also, we have 3 deputy members of the AGE present at the meeting: Mr. Thomas Griffith, Mr. Volodymyr Kuzmenko, and Mr. Vitaly Makhinchuk. Alexander, I will briefly explain the regulatory framework and procedure for conduct of this interview. The interview is one of the mandatory stages of evaluation of the criterion of high moral qualities of candidate for the position of the judge of the Constitutional Court of Ukraine. The purpose of this interview is to provide you with the opportunity to refute any doubts that the AGE might have with respect to your compliance with those high moral qualities that are required for filling in the position of the judge of the Constitutional Court of Ukraine. You communicated with the AGE. We are grateful for that. You've provided answers to a range of questions that we sent you in writing. In connection with this, I have to warn you that today you cannot provide information, documents, or other materials. If the advisory group made a request to provide them earlier and for analysis, and you did not do that for some reasons, or if you want to inform us about something that we did not know earlier, and we could not analyze this information. At the same time, we can make an exception to this general rule if we decide that such exception is justified. I would also like to inform you that our interview is being recorded and broadcast live at the resources of the AGE and at the website of the Constitutional Court of Ukraine. In connection with this, I would like to draw attention of the AGE members and you, Mr. Alexander, as the candidate, that in case it is necessary to use some sensitive data or information with restricted access, we will suspend live broadcasts so that such information would not be disclosed outside of the premises where we are working now. Mr. Alexander, we intend to complete the interview with you within 1 hour. I will ask you to be very concise, brief, and to provide answers to the questions asked clearly on the essence of the asked questions so that we would not disrupt this time limit. At the end of the interview, we will provide you with the opportunity to address the AGE with a closing statement. This closing statement should not last more than 5 minutes. Mr. Alexander, before members of the AGE start asking questions to you, I would like to draw attention of all the viewers of the interview to the fact that you, Mr. Alexander, already participated in the competition for the position of the Judge of the Constitutional Court on March 4 of 2024. The advisory group of experts already held the interview with you within the framework of evaluation of moral qualities compliance. If someone is interested, you can find this recording in YouTube and refresh it in memory. Mr. Alexander, do you confirm accuracy and credibility of all the information that you provided during the previous competition for the position of the judge of the Constitutional Court, in particular during the interview on March 4 of this year? Yes, I confirm that. Would you like to add something to those issues and questions that were raised during the previous interview with you? Yes, I want to add. Okay. Okay, then we are ready to start interview with you. And now I'm passing the floor to the co-rapporteurs regarding you. Uh, and that is Chairman of the AGE, Mr. Alerzalar, and Member of the AGE, Mr. Vasil Shakun. Please, colleagues, the floor is yours. Who will be the first? Switch on your mics.
Mr. Secretary, I will start with questions. Mr. Tkachenko, my first question relates to the decision of the Zavodsky District Court of Mykolaiv, dated 31st October 2019, under the claim of AGK Parma. You were obliged to return to the claimant the metal garage box number 90, located on the territory of AGK Parma. The Mykolaiv Court of Appeal, by its decision of 27 February 2020, dismissed your appeal and upheld the decision of the Court of First Instance. Therefore, the court decision has entered into force. My question is, have you complied with this decision?
No, I have not complied with it.
So, the provisions of Article 129 of the Constitution of Ukraine?
Yes, I know about this. If not,
connection between non-compliance with the court decision and this constitutional provision?
Connection? Yes, I see the connection.
What is this connection? How do you see it?
Article 129.1 of the Constitution of Ukraine sets out that the court decision shall be fulfilled following the procedure set out by the legislation of Ukraine. And the legislation of Ukraine, confirmed by the case law of the Supreme Court, sets out that the decision should be fulfilled not by the debtor, and I'm the debtor under this case, but by the bailiff service. So this decision should be enforced not by me, but by the bailiff service. And I do not have the duty, according to the Constitution of Ukraine, to fulfill this decision of the court. That's firstly, if we decide that this decision is legal. If the decision is recognized as legal by the Supreme Court, it does not contain references to the right of ownership of Parma. Besides, the claim contains references to false documents. AHK Parma, while submitting the claim to the court, has provided the agreement of the purchase of the garage dated 1993. But AHK Parma was created 6 years after that, allegedly after the date of this transaction. But the court did not.
I understand that you disagree with the court decision, but I hope that I didn't understand you right when you said that you are not obliged to voluntarily comply with the court decision based on Ukrainian constitution.
Yes. No, neither voluntary nor during the forced procedure.
My next question is the following. You, as a judge of the Commercial Court of Mykolaiv region, you considered a case number 6/193/09. It was the claim of Parma Limited Liability Company, third party Parma Auto Garage Cooperative against Mykolaiv City Council for recognition of property rights. And on 22nd July 2009, you issued a decision recognizing the claimant's ownership of the buildings and structures, including the garage. At the time of this decision, you owned a garage in the Parma AGC. Why did you, being in a direct conflict of interest, not recuse yourself from the case?
First of all, with respect to these circumstances, there are two sources of information. The first source of information is my explanations given to the AGE and my testimonies as a witness during the consideration of this case regarding the failure of fulfillment of which I was recognized as lacking integrity. And according to my explanations, and I support them now, yes, I owned the garage during the consideration of the case that you referred to. But during our dispute with you in the court, the AGE in the recusal stated that the AGE does not check correctness, legality, and justification of national bodies' acts, including court decisions. With the court decision under the criminal case, with respect to which I provided the answer, it has been established that during the consideration of the case by me, I did not have the garage in my ownership. Secondly, that the decision that I am not obliged to fulfill establishes that the garage was transferred to me only after I took the decision. So, with that decision, which I failed to fulfill, and for failure to fulfill which I was recognized as lacking integrity, it was established that I got the garage in my possession only after I took the decision under the case you referred to just now in your question. So, according to the court decision, I did not have the garage in my possession in AHK Parma as of the moment of adoption of the decision. And in the criminal case, the court decided that my testimonies about me having the garage were inaccurate, but the court refused to initiate the criminal case with respect to me because I did not provide this testimonies intentionally, so it was established that I negligently provided these testimonies. So we either have to trust the court decision, which established that I did not have the garage, or my testimonies, which were recognized as uncredible by the court decision. And my testimonies, which I was given during the previous competition, I support them. But the court believes that for some reason, based on my individual peculiarities or mental capacities or age, cannot provide testimonies as a witness because I do not understand those circumstances which I specified during the competition and during the court consideration of the cases. If I have explained.
Request of the advisory group of experts, you provided a copy of the motion to the deputy head of the Zavodsky department of the State Enforcement Service in Mykolaiv, dated 12 April 2021, to prevent the unlawful seizure of property not specified in the court decision. You have attached photograph of 3 metal garages that are stacked on the top of each other to this petition. So you show this as an attachment to the petition. How can you explain the purpose of this photo? And is this photo a true photo? So there are 3 garages or there is 1 garage?
Yes, I provided this photo just to show the absurdity of decisions adopted by courts which which came into force. The first garage, with respect to it, I have photos of paying contributions for membership, and it shows that as of January 1st of 2008, I already had the garage in my possession. The second garage, according to the decision dated 2019. It was established that this garage was installed there only after July 11 of 2008. So according to the court decision, this garage was installed on top of the garage that I already had as of January 1st. Besides, during further consideration of the case, AHK Parma refused from the fact that this garage was bought in 1993, and AHK Parma stated that it was not from MP Parma as specified in the claim under this case, but that it bought from an individual. So according to the case materials, there are three garages. The first one that I had in my possession since 2007, the second one that was bought by Parma in 1993, and the third garage that was bought from an individual in 2006. So that's why I stated that on the same place AHK Parma installed, according to the court decisions and the case materials, so it has installed three garages on the same place.
And until now,
But the main issue for advisory group of experts from the perspective of our criteria we are assessing is that you didn't self-recuse yourself in this case. And during the interview with the Ethics Council on 14 September 2022, you admitted that you had not submitted a recusal application, but you stated that in your opinion, your decision did not violate anyone's rights, but only confirmed the existing ownership of the garage by the citizens, members of the cooperative, and gave them the opportunity to document this right. However, then during the interview with the advisory group of experts on 4th of March 2024, you confirmed that there was a conflict of interest in this case and that it was your mistake not to recuse yourself. Let me remind you also that during your interview with the Ethics Council on last day of May this year, and in response to a written request from the advisory group in the current competition, you stated that you had no obligation to recuse yourself. So please explain your discrepancies in your explanations. Once you say, yes, this was the a violation of the conflict of interest rule, I should recuse myself, and then you said, no, there was no violation. What is your final position on this issue?
Моя позиція була з самого начала,
my position from the very beginning was that I had to declare self-recuse, but that I said that there was no grounds for self-recusal because I didn't have the garage at the time of this proceeding, and because there was no garage, I had no grounds to declare self-recusal. And if we trust my testimony, I had reasons for self-recusal. That was a violation from my side.
I pass the floor now to my colleague Vasil Shakun.
У мене є таке питання.
I have the following question. Answering in response to the advisory group's request, you provided a copy of the notice on the unreliability of the statements made by the judge in the judge's integrity declaration dated the 20th of November 2023. In the said notification addressed to the High Qualification Commission of Judges, you state that you as a judge in your declarations of integrity for 2016, 2019 and 2021 did not report knowingly giving false testimony on cases. Numbers, yes, yeah, I know. You received in the second half of 2009 for the decision in case an unlawful benefit in the form of the right to use a metal box garage, which AGC Parma purchased from SE Parma for 270,000 Karbovancy under the agreement of 22nd August 1993. Do you verify? Do you agree with that? Yes, I gave testimony that garage was in my property. The court identified that garage became my property after I processed the case. That's why they deemed my testimony untruthful. So I asked the court to applied to court for starting a criminal case against me for giving not a truthful testimony, and the court refused to start the case because I gave the untruthful testimony not conscientiously. One more question. You participate in many competitions on different positions, constitutional court, member of the Supreme Council of Justice, member of the High Qualification Commission, as you informed the group without any result. What were the motives for you to participate in all that competitions almost at the same time? I will give you an answer. Now we are at the stage of evaluation of integrity. Integrity means independence, honesty, legality of incomes. My motives, this or that way, cannot influence those components which the advisory group set up at this stage. But I will tell you that my experience, which I have, gives me grounds to participate in any competitions in order to continue my work in the system of justice. And for me, it's not that important in which authority I will participate. And I would like to be from the Congress of Judges, but okay, it's a very dubious point, but we'll take it into account. And the last question: in our group, we have such a photograph. Is it a real thing? No, this is my conventional scheme. So you deceive the group of advisory groups submitting such materials. I explained that this is a conventional scheme, and I gave explanation. Yes, I've heard, but this is just a lack of respect to the advisory group. You are trying to deceive us because you submitted this photograph and then you tell that there is one, there is second, there is third. Why these games with us? I will tell you, because at my first competition I applied to the advisory group in the State Bureau of Investigation. They have a case and they have all the necessary information about these criminal cases. You gave us a good idea, as far as I understand. You're going to continue participation in competitions. Okay, then we'll apply to the Bureau of Investigation. Dear colleagues, are there any more questions to the candidate from other members of the GG? No questions? Then, Alexander, we are ready to finish the interview. And as we told you at the outset, now you are given an opportunity to make a concluding statement for not longer than 5 minutes. So the floor is yours. I would like to add why I didn't fulfill the decision of the court according to the constitution, because nobody is obliged to adhere to illegal decision, and besides this, it was done against the law. Then the decision of the court does not correspond to the first part of the decision, and the first part of the decision means to take the property and then to return it. So that was a condition for returning the letter. About the garage, beginning with 2016, in no decision there is a reference to court decision recognizing property rights on my property, and this is the violation of requirements of procedural code, that the court does not make reference to the proof on the basis of which they took a decision. So I would like once again to apply to the head of the Supreme Court. Please give me a proof on the basis of which the courts deprived me of the property rights, and I'm blaming Supreme Court and some dozen of judges who took decisions with violations, and they are trying to undermine my business reputation and to hide the systemic violations committed by the judges of the Supreme Court for a number of years. And during our dispute in the court, I would like that every item on which I would be recognized as a person of not integrity, I would like to be indicated why that decision was taken. When evaluating the criteria of high moral qualities, the conscientious violation, of whether this violation was a separate event or it led to any violations of my rights. I would like to apply this point. That's all. Thank you for the answers to the questions. And on this, the DG announces the end of interview with the candidate for the position of the judge of the Constitutional Court of Ukraine, Tkachenko Oleksandr Vasilovich.